Today we're going to be talking about civil liberties, and specifically, at least in the United States, when it comes to basically the Bill of Rights. So let's start off by explaining why there's a Bill of Rights in the first place. Now, imagine you're in, 1700s, just had this revolution, or you're in the process of having this revolution, and you're deciding on your new country, and you start thinking to yourself, well, what should we protect? What should our government be about? And so when the government was first created, using our Articles of Confederation, then our Constitution, the idea was this document that we created, this Constitution, was going to be, this is what your government can do. This is what your government is designed to do. And that was really important. So you needed a foundation for what your country would be. The problem with it and it started to get realized by a number of people who were not, really strong federalist ideas of, having a strong central government, is there any protection for the common person, or basically anybody who's not actually part of the government structure? And at the time, there really wasn't. But again, historically, let's look at what was going on. There never really was protection for people anyway, other than, what they were able to, scrounge out for themselves, if there was ever like a revolution or some kind of war to take place. So when we hit the time where we were deciding on this brand new government to announce our liberation from the British monarchy, the people who came across, this idea, this new idea of having this country, thought to themselves, shouldn't we also protect our rights that caused us to have this revolution in the first place? And so you had people like Thomas Jefferson, who argued and created basically the Bill of Rights, which was the first 10 amendments to the Constitution, as a process to explain, sure, we'll have this government, but at the same time, these are some of the rights that we should have and we do have, and therefore going forward, these will be part of our foundation of this country. And so that becomes literally the foundation and bedrock of the country that moves forward. So a couple of quick little sidebars to kind of keep in mind, because it often happens where people talk about the Bill of Rights and the first 10 amendments is like almost like they're the first 10 commandments. They're not necessarily that. And one of the other problems we run into is, like, we'll refer to as the First Amendment. And people will actually say that the First Amendment is the First Amendment because it's the most important amendment. It's not. As a matter of fact, it was not originally supposed to be the First Amendment. It was like number 4. So, I mean, the idea was the other ones that kind of got shot out of the way basically moved out of the way until one became one. And so it wasn't really because it was the best. It was just because it happened to be the first one on the list. And so, but we needed this Bill of Rights in order to say, hey, look, you can't take away all of these rights just in order to institute a country. And that's something that was kind of new. And when we finally did it, it was required in order to actually make the government happen, because the people who wanted this Bill of Rights would not allow the Constitution to actually be put in place and ratified until that actually happened. So keep in mind, if there had been no Bill of Rights, chances are pretty good we wouldn't have a country today. Either that, or it would be a much different kind of a country, much top heavier, and with no idea of, or no concern for any of the people, who make up this country. So, well, let's talk about some of the amendments going forward. So the First Amendment. The First Amendment guarantees freedom of religion, speech, press, assembly, and petition. It's a really important amendment, but like I said before, it's not more important than the others, but it's important as part of all of the others, because it is a fundamental set of rights, and it becomes literally so significant going forward in this particular country. So when the document was first created, remember the First Amendment and all of the amendments are meant to protect everybody. But at the time, we weren't really representing everybody. And so over years, what has happened is our Supreme Court has actually substantiated a lot of these laws to actually stand for more and more people, because it was supposed to encompass everybody, but at the very beginning it didn't. And so, like, you had slaves before, you had women before, you had all sorts of other demographics in this country who were not completely represented. And because they weren't represented, they were often seen as secondary citizens, and therefore didn't get the same protections under the law. Now it's designed so everyone gets protections, and there's still a couple of delineations out there that may or may not end up being encroached, or not encroached, added into the whole gist of who all gets and deserves protection, because the idea was to protect everybody. So one of the other important parts of the First Amendment was freedom of religion. And so it's kind of it's kind of important to understand what that actually means. It was done in a couple of different clauses within the Constitution itself and within the Bill of Rights, such as the Establishment Clause, which prohibits the national government from establishing a national religion. Now, that's kind of important, because what it's saying is your national government can't decide that Christianity or Catholicism or any other type of religion is more important or is the national religion. And so that's literally the Establishment Clause. The Free Exercise Clause, it prohibits the U.S. government from interfering with the citizen's right to practice his or her religion. So if you believe something completely different than everybody else, even if you're not part of the majority, you're allowed to believe whatever you want to believe. And you got to remember why we have that as part of our system. It has a lot to do with, we came from a country or a land where there was subjugation based off of religion. Different areas in different parts of the monarchy where literally you had to believe this or you had to believe that. And if you didn't, basically you're put in jail, or executed, all sorts of things like that. Fortunately, we've kind of incorporated some of that into our Constitution with our Bill of Rights, so that never ends up actually being a case anymore, or it shouldn't be a case anymore. Then there's the Establishment Clause, which we were talking about before. So there's a certain amount of standpoints that over years, because of the Supreme Court, that verify or vindicate whether or not something does meet the Establishment Clause. Sorry, my throat's kind of giving me a problem. We have what's called the Lemon Test. And so we run this test to make sure that if you're creating some kind of law, you can't actually use that law. Let me rephrase that. So if you have a law that's created, it can't be designed in some way that's actually going to establish any type of religious value or controls within the system. To give you an example, so like the Lemon Test takes, first, it can't have a secular purpose, or if it fails the Lemon Test, if it has a secular purpose, two, it's neither advanced nor inhibits religion, and three, it does not foster an excessive government entanglement with religion, and therefore it passes it. The way that was worded was kind of backwards, but you get the idea. And so There's been all sorts of attempts to change the lemon test, or not to change the lemon test, but to change the requirements in order to get past the lemon test. Because one of the problems we have with the Establishment Clause is, as a powerful group or entity wants to use its own religion as the influential, political basis, sometimes you end up going right up to the very, to the mat with the lemon test to make sure that that doesn't actually happen. So then there's the free exercise clause, which means you should be able to, worship whatever you want, or not worship if you want. And that's often been kind of one of those really weird stipulations, because there have been attempts in the past in order to establish the fact that someone doesn't have a religion as some kind of crime itself. So you have both the non-requirement that you're neither required to be a religion, and you're not required to be a specific religion, if that makes sense. So we have some constraints based on government, like there's certain things that can happen that constitutionally probably shouldn't, but they still happen, such as government has prayer meetings before certain meetings. Now, those are because the people who are involved in government decided that's what they actually want to do. And so the way it's usually argued is, and the way it's justified is, their decision was decided that it wouldn't have made a difference if they were part of government or not. They were still going to have these things happen anyway. And so therefore, it kind of, I want to say, manages to pass the smell test of the lemon test, but you can kind of take that with a grain of salt. But overall, as long as it doesn't force anyone to actually, accept one religion as significant or more important than another, then basically it generally passes the lemon test kind of going forward. So let's talk about a couple of the freedoms that have actually come from speech and press. One of the negatives, or one of the challenges to it, was in 1798 when we had what were called the Alien and Sedition Acts. And so this basically banned political criticism by minorities that weren't in government power and had no decision making. So basically, if you didn't like what somebody was saying, and they weren't part of the political structure, basically their speech was considered a criminal offense. And so this was kind of important. This is at the very beginning of our country, and the judges tended to be very partisan. And so whenever somebody came up in front of them, they would generally fine them, just for being accused. If you were accused, you're basically considered guilty. It took Jefferson's election to when he became president to actually end the acts. One of the first acts that Jefferson did upon coming into office was to pardon everyone that was tried under the Alien and Sedition Acts. Probably not one of the better times of the United States. There's a lot of anti-government speech during the many, many different years. And so one of the stipulations, or one of the boundaries for it, was a term called clear and present danger. So if you say something that creates a clear and present danger, or the perception of a clear and present danger, then basically it was outlawed as actual speech. So a couple of things to kind of keep in mind, or to think of as examples that are generally used quite often, such as, yelling fire in a crowded movie house, something like that would cause people to end up, hurting each other in order to get out of the place where you yelled it. So that's kind of like where they set the parameters for the idea of creating a clear and present danger. So sometimes the speech is assumed okay during peacetime, but sometimes during wartime, in order to kind of fight certain bad thoughts, I guess is the best way to put it. Sometimes speech will be curtailed, and usually what ends up happening is after the escalation of actual war, um, the Supreme Court usually starts siding towards the people who are actually, put in prison or brought up under trial, and then turns most of those cases around. It's generally how it's happened over the years, and usually in most of our wartime kinds of cases involving freedom of speech and press. So a couple of things to think of, to understand about, like for freedom of speech. There are two kinds of speeches you generally can't do, which one is called libel and one is called slander. And quite often people mistake the two of them. And so libel is actually written statements. So if you write something down that's basically calling someone's reputation into disrepute, can't even say the word today, that's considered libel. Slander is the same thing, except it's statements out loud. So if you say something, it's slander. If you write it down, it's libel. And so, but you have to prove the actual, malicious intent in order to make that sort of thing stick. One of the other things that's often used as an example, or used as a parameter for whether or not something is allowed to be curtailed in freedom of speech, which is obscenity and pornography. So part of the problem with that is well, the way it works out is it's considered illegal and not allowed because it's basically supposed to be a harm to the society in general. But part of the problem is, and that's where I was going with it, is it's often debatable as to what's actually considered obscene. And so years back, Potter Stewart, the Supreme Court Justice, who was kind of going blind at the time, was part of one of the cases where they were first actually deciding whether or not someone was actually considered, if material was considered to be obscene or pornography. And his line is, "I know it when I see it." So part of the line of what I was actually going to say is, during this time, what happened was Supreme Court justices were all kind of sitting around watching pornography movies, not to watch pornography movies, but to actually observe whether or not it was obscene or not. And like I said, one of the Supreme Court justices was actually going somewhat blind. So one of the other justices sat behind him and kind of described every one of the materials, scene by scene, which is kind of funny if you think about it, but it's literally how it actually happened. But all they remembered during the whole time was a Supreme Court justice saying over and over, "Oh my, oh my, oh my." So anyway, you get the idea. So basically, the standards for obscenity and pornography kind of change over time, kind of as society changes over time. So as society believes some things, they change their ways of thinking over the years. And so sometimes the levels go higher and lower based on different things. During the during one of the Bush administrations, there was attempts to cover statues that had nude female tops, because that was just historically how the statues were made. So I mean, stuff like that. You get an idea. The obscenity test, because we tend to run 3-part tests on quite a few things. We have what's called the Miller test, which was combined with the Roth test. And so basically, in order to find if something's actually obscene, it has to meet these standards. It has to be 1, patently offensive. It has to 2, lack serious literary, artistic, political, or scientific value. And 3, it has to appeal to the prurient interest. That last one's really important because what happened during the 1960s is there were attempts by the pornography industry in order to, appeal to being not obscene. And the way to do that was they would actually do their pornography movie, and at the very beginning or towards the end of the movie, there would be a scene where somebody literally went out and started talking, poetry or something to that effect to say, look, we have literary and artistic value, and so therefore we're not obscene. So let's talk about protected speech. Hopefully there's a lawnmower in the background that just keeps turning on and turning off again, so hopefully this time it will not turn on. Anyway, so let's talk about protected speech. One thing that the government is not actually allowed to do is to institute what's called prior restraint. And so what this means is the government comes out and says, you can't do something in the future or can't say something in the future because it's bad or whatever their reasons are. And so basically the Supreme Court in 1971 looked at a case called the New York Times versus the US, which was basically the issue happened to be the Pentagon Papers. And so the New York Times was going to publish the Pentagon Papers themselves, which obviously the government didn't want them to do. So basically they set up what was called a prior restraint, which they're not supposed to actually be able to do, which got appealed to the Supreme Court. But while it was being appealed, Time magazine actually took the actual story and ran with it anyway. And so basically it made it into the press anyway, and there was nothing the government could do about it. So the case was basically dropped because there was really nothing you could do about it because it was already released into the public domain. One of the other protected speeches that exists is called symbolic speech. The government has generally always tried to put forth the idea that you're not allowed to burn the American flag. And so patriots would not want you to do that because, that should just kind of make sense. And so in 1989, there was a case, which was Texas versus Johnson, where basically the flag was burned, and the reason for it was where they stated that, or the people who burned the flag stated they were doing it to show how free they actually were. Well, during this case, while the Supreme Court was hearing this, a group of veterans, combat veterans, originally from the Vietnam War, protested in front of the Supreme Court and actually burned a flag indicating that they wanted to point out that they had defended the country and they felt it was so important to our freedom to be able to burn the flag rather than just the fact that the flag was a symbol itself. So it's why it's called symbolic speech, because the flag represents something, and they were saying you basically can't say you can't burn a symbol of anything. And so you can't do that, and that's what Texas versus Johnson decided, that basically you can't put a constraint on burning the flag. So there's been all sorts of attempts to kind of go back to that particular case and turn it around. So you keep seeing new cases being tried that are very similar to it, but basically it still withstood the test of precedent. One of the other cases that's actually important when it comes to protected speech, which is hate speech. So there was RAV versus the city of St. Paul, which was kind of the idea that you can't, literally, say that you can't say certain things. And so that happened in 1992. And while that case cited that you can't create hate speech, we've instituted all sorts of hate crimes based off of saying certain things. So those kind of cases are still kind of running through the Supreme Court, and usually when they get to the Supreme Court, the decision has generally been that you can't actually put prior or can't have that under protected speech. But again, depending on the case, and sometimes it has more to do with the politics of the time than the actual whether this is the right or wrong thing to do, as to how those kinds of cases will get decided, and then that will set precedent for all future cases kind of going forward. Let's talk about the Second Amendment, which is another one of the important Bill of Rights that were actually instituted as part of it. And so during the Second World War, during the American Revolution, there were attempts by the British to actually confiscate weapons. And so the idea of the Second Amendment was to make sure that in case the government ever becomes so oppressive, that people should be able to get together, or let me rephrase that, people should actually be able to take up arms against the government itself and overthrow it because the government has become an oppressive regime. So that's been interpreted years and years later to something a little bit different than what was originally intended. Now it's that nobody should be able to infringe on the right to bear arms. And because certain organizations like the National Rifle Association, National Rifle Association, has put a lot of clout and money behind all of the different issues kind of going forward. They seriously defend against any attempt by government to infringe on any Second Amendment right. So part of what the actual regulation or the actual amendment stated was you're supposed to be able to have a regulated militia, but one of the problems we've always come into is the definition of what a regulated militia means is not always that clear, and that gets decided almost by the thought process of that particular day. So the issue is still up there, but again, it's another one of those rights that you just basically can't take away because you don't like it. And so again, the Supreme Court sides very much on the side of whether or not it belongs as a right, because it's part of one of the amendments, unless a process happens to rescind the amendment, it is the law of the land. So let's talk about due process rights. The Fourth, Fifth, Sixth, and Eighth Amendments were all pretty much put together to kind of protect certain legal issues and the legal processes in the way that they actually happen. They generally protect those who are accused of crimes. So, but there's continued attempts by the government to limit these rights, usually in the name of security and safety. And quite often after the situation has played itself out, the Supreme Court turns around and backs up the rights of people again. So that's generally how it works. Doesn't always mean it's always going to happen that way. Let's talk about the Fourth Amendment. Fourth Amendment basically states no unreasonable searches by the federal government. And so this right has gone back and forth with Supreme Court. Over the years, it's become weaker and weaker. What happened was, or very recently, is the Patriot Act happened, basically after the 9/11 attacks. And so it softened a lot of the rights that the Fourth Amendment basically stated that, you had those rights. Well, Patriot Act said in order to protect the country, you needed to kind of infringe upon some of those rights. The Fifth Amendment, which is often used because you see it in police shows all the time, which is the right not to incriminate yourself. So without a really good attorney, quite often this happens in a situation and the right is basically trounced upon by the law enforcement community. Because if you don't know your rights, there are police agencies that will go through a lot of work to basically run everything against you before you ever get the chance to actually see legal counsel, and therefore not even know your rights before you've given up pretty much most of those rights. One of the rights that have actually kind of happened over time based off of a Supreme Court case was Miranda versus Arizona. So we have what's called Miranda warnings. So part of the problem with a Miranda, which is basically you have, the right to remain silent, have, that whole thing that you you hear the police say all the time on police shows. Quite often, voluntary confessions, because that's what it is, you're voluntarily confessing, they're not often that voluntary. And so quite often that becomes an issue more than the actual confession itself, whether or not it was given voluntary in the first place. So basically, the Supreme Court's lessened a lot of the impact of Miranda over the years because there's a belief that people are getting away with too many things. Doesn't necessarily have to be the case, but as public perception changes, sometimes that causes the Supreme Court to kind of change in some of their decisions as well, or at least to coax it a little bit differently. Then there's the exclusionary rule, which basically is if evidence is obtained in an erroneous fashion, it shouldn't be able to be utilized in a criminal trial. But there have been exceptions to it to cause it to actually happen. This, unfortunately, like the Miranda situation, it's slowly being ignored by the courts. In the last few cases, basically the Supreme Court has kind of sided more on the law enforcement side, and so we run into this where they allow certain things to actually happen because of the idea that you're protecting society from, unsavory elements. It's kind of how those kind of issues take place. The next one that's actually important is probably the Sixth Amendment. There's a case called Gideon versus Wainwright, which happened in 1963. And in this case, basically, the way the old situation used to work was if somebody wanted to be heard by the Supreme Court, you literally had to, pen your appeal directly to the Supreme Court, and if lucky, 4 justices would decide they actually want to hear it. And so the problem with that has been over the years is, if you can't write, if you don't have the ability to write, or not smart enough to put together a coherent argument, or you don't have an attorney, basically majority of the cases were never going to be seen or heard from. So those sorts of people kind of got pretty much swept under the rug. Well, basically the Sixth Amendment kind of forces the idea that people should have attorneys. And that's what Gideon versus Wainwright was, is you should not be put on trial, for basically to argue for your life, time, not just death penalty cases. But the fact is, if you don't have the ability to defend yourself, then you have literally little recourse to defend against the government. And so what the Sixth Amendment was all about, and what Gideon versus Wainwright was all about, was to make sure that everyone gets an attorney. And Abe Fortas, who was the attorney who eventually became a Supreme Court justice, what he argued was that it's actually beneficial to the state, as it would save them money on appeals and all that, those kinds of things, if they actually provided an attorney rather than have to keep going through the process of appealing cases over and over again because of the constitutional issues involved in every one of the cases. So one of the other issues that kind of comes up for civil rights and civil liberties is a concept called 3 strikes laws. This was a more recent kind of thing around the 1980s, kind of going forward. And the idea is that after you've done something, or committed a crime 3 times, basically you're out. It's kind of like the old baseball metaphor. And part of the problem with that is they started collapsing this on pretty much all cases. So if somebody had done 2 small misdemeanors or even 2 small felonies, because there are differences between, non-violent felonies and actual violent felonies, but the third one was the one they're on trial for, that 3rd strike would basically mean you're going to jail for the rest of your life. And so that became a huge problem with 3 strikes laws, and it's kind of generally why a lot of judges and attorneys don't like to have 3 strikes being, made as part of the requirement. Another thing is judges don't generally like to be told what to do. So when you're telling them you have to decide these particular laws based on this, sometimes what will end up happening is a judge may actually, decide something completely the opposite direction just because he or she is not happy having to be told you must actually put somebody in jail for the rest of their life. So they may just try them and declare them innocent based on other certain circumstances. So that was kind of happening a lot, and that's kind of what's killed a lot of the idea of 3 strikes laws. But there's still an attempt to make them happen because it looks good to a prosecutor for 3 strikes to actually happen, because they're basically looking for elections, and people like strong, prosecutors, and that's kind of what generally works well for them. So that's kind of the ideas of the things that are important on civil liberties and civil rights and kind of what we should be actually focused on. So keep those in mind when looking at these particular issues, and make sure you read through the material as required. Thank you.